Hello, everyone. I think this is plenty loud enough. As I think everybody here in the room knows, I'm Terry Fisher. This is the first of 6 special events that accompany both the Harvard Law School course on copyright and the parallel edX course on copyright. The topic for tonight is the interests of authors. Here's the genesis of this event. As all of you now know, copyright law and copyright theory depends upon some assumptions about what motivates and concerns artists and authors. Some copyright theories are interested in this question from an instrumental standpoint. They pay attention or purport to pay attention to what artists and authors value in order to know what buttons to push, in order to induce them to create socially valuable things. Other approaches are concerned with the motivations of artists and authors for more principled or moral reasons, thinking broadly that artists deserve some of the things that they desire. But one way or another, the interests of artists and authors figures prominently in this field. But it's rare for lawmakers or judges to ask the artists and authors themselves what they care about. So the idea behind this session is to try to remedy, or begin to remedy that gap. So we have 3 distinguished and accomplished artists and authors from 3 different fields here, and 1 prominent copyright lawyer who has worked very closely with many artists and authors, and they will speak to this question. Now, before I introduce them, let me say a little bit about the format of this session, because it's pretty unusual, and I think it's helpful if all of us are aware of what's going on. So there are several, roughly speaking, concentric audiences for this event. The first primary audience is, of course, you assembled here. All of you are, or almost all of you are, enrolled students in the Harvard Law School course on copyright, and you will be participating in this event in the fashion that you're accustomed to, with one modification, which is when you want to make a comment, ask a question, please raise your hand, but before speaking, somebody will deliver to you a microphone, which is important so everybody else can hear you. Next, at the back of the room are 20 Harvard Law School students, all of them teaching fellows in the online edX course. Many of you are simultaneously enrolled in the Harvard Law School class. Each of the teaching fellows is at the moment online with students who are enrolled in the edX initiative. So that's the third audience. There are 500 people, approximately, from all over the world now who are watching this event remotely via a live webcast. And they are, we hope, organized into sections of 25 each. And so those of you who are watching from afar will be participating via chat in a discussion of the events as they go along, and your teaching fellows are then in a position to relay into the room comments and questions from you, the edX folks. All right, that's audience number 3. Audience number 4 is there are parallel to the edX initiative some satellite courses examining copyright. Sarah Shaw and Charlie Nesson, for example, have organized such a course in Jamaica. Tara has also organized a course in the United Kingdom, so welcome to those of you who are watching from those groups. There are only 2 more. The next to last of the audiences consists of the members of the public at large who have been invited to watch this via webcast through my homepage. And finally, the event's being recorded, so some people, I hope, will be seeing this event at a future date. I hope it's useful to all of you. So those are the layers. It's a curious system. This is the first time we've attempted it. I hope it works. The probably most visible manifestation of that structure as we go along is that during the discussion, I will be making an effort to oscillate between those of you enrolled in the course and those teaching fellows who will be speaking for the online audiences. Okay, so that's the plan. Our 4 speakers, as I've mentioned, exemplify several different fields of creative endeavor. So the first of the group to speak will be Richard Kelly. He's on your far left. Richard is a professional photographer, has been since, I just learned, the age of 12, a professional photographer since the age of 12, partly professionally trained, partly self-trained, has many honors and responsibilities, including former president of, now a member of the board of directors of the American Society for Media Photographers, and is, as a result, intensely interested in and knowledgeable about copyright issues. So he'll be our first speaker in just a minute. To his right is Bill Landay, who is a recovering lawyer. Bill graduated from Boston College Law School, was a prosecutor, and then discovered that his true calling was writing novels. And it turns out to have been a true calling because his novels are deservedly very well received. The most recent one, called Defending Jacob, has been favorably reviewed in the New York Times. I actually think I have here a shot of his other 2 books as well. Here's a self-portrait by Richard. Here are Bill Landay's 3 books. Having read the reviews, I hope soon to begin myself trying Defending Jacob, and if all goes well, check out the others also. Our third speaker is John Drake, a Harvard College graduate who wears at least 2 hats. The more prominent one, his day job, is he's the Director of Communications and Brand Management at Harmonix Music Systems. The name is probably not very familiar to you, but the products probably are. This is the company that has generated a series of highly successful and influential music video games, including Guitar Hero and Rock Band. In his spare time, he also is himself a member of a band, The Main Drag, an indie rock band, at least the way it's characterized in the media. Okay. Last but not least, Dale Sandali is one of the leading litigators in the United States in the fields of copyright and trademark law. She is the head of the intellectual property group at Kirkland & Ellis in New York, and has been involved in some of the most high-profile and influential decisions in this general field. Among her clients are J.K. Rowling in the left-hand corner of the slide, 20th Century Fox, in particular in the Daystar case, and just most recently, the makers of Tetris. She is most often representing in copyright and trademark controversies artists, and so has gotten to know them very well, so that she can draw, and will be drawing here, both on her litigation experience and her knowledge of the personalities and motivations and concerns of her clients. It's conceivable at some point we will touch upon a controversy in which she and I were opponents. This was the Hope poster controversy. Maybe, maybe not. We'll see. So thanks very much to all 4 of you for being willing to participate in this event. Our plan is to collectively speak for no more than 45 minutes, to leave close to half of the time for questions, answers, discussions. So as we go along, please think of how you would like to intervene. Richard, you're up first.
Do I need the clicker?
Well, you don't need it, but it might be convenient.
Okay. Which way do we go here? Give it a second. Well, I'll start anyway. My name is Richard Kelly. I'm a photographer. I live in Pittsburgh, Pennsylvania, which is a good place to be an artist. I'm here sort of wearing multiple hats. First and foremost, I'm an amateur. I love making pictures, even if it's just for myself. And then secondly, I'm a professional, meaning that some people hire me to make pictures for them. And this is how I make a living. This is how I feed my family. So I'm going to show you some pictures and talk a little bit about how I got to this point today. So of course, a lot of what I'm showing you is available on my website. I also decided to show you some pictures of me working because I think sometimes as photographers, we're all photographers. Everybody in this room probably has a camera on them right now. And so I think that sometimes we forget that there's a difference between the amateur and the professional. So I thought I would show you a little bit about what that looks like. I make pictures for companies. They ask me to help them sell their idea or sell their product. And it's not always glamorous work, but sometimes I'm 15 feet off the ground, and sometimes I'm working with beautiful models. It's a hard job, I know. But I do love what I do, but I have to make a living. And there's a certain balance in being an artist and being a professional. And I think all three of us probably can talk about that a little bit. So these are the kind of pictures I make, and I get paid, some people would say very well to do this. But it's a career where today everybody is a photographer. And so I feel like I'm competing with people that maybe 15 years ago wouldn't even be in the same realm. And I mean that because the cost and the barrier to entry has been lowered. And I also say that in an exciting way because I think this is a great time for photography. The same tool that I use professionally, we all use to communicate. And I think that it's a great time for us to be able to make a picture and send it to somebody in moments. I was in China a few years ago. I took a picture of the Great Wall, and within moments I uploaded it to Facebook, and I had people responding to it. I mean, that's pretty fantastic. So I'm excited about photography, but at the same time, it's a hard time to be a professional because everybody thinks they can do it. And secondly, I think it's hard to be a professional because we're living in a time, and I hope we can talk about this a little bit more during the question and answers. I feel like we live in a time where there are two sides to the legal component to photography. There's the copyright, which I would describe as the traditional publishers and the traditional music studios and the record companies. And then on the copy left side, where cultural institutions and technology companies want things for free. And I find myself stuck in the middle, often with arrows coming from both directions. So I'm hoping that we can talk a little bit more about that, and I can talk a little bit about some of my feelings, because depending on the day, I can feel really differently about it. But these are the kind of pictures I make. In fact, here's a writer who lives here in Massachusetts. I love writers, so maybe we can do that picture later that you wanted to talk about.
All right.
And I also teach. And so I'm really happy to be here because I love working with students, and I feel that I'm a lifelong student. Never stop learning. And that's one of my guilty pleasures about being a photographer, is that for a few moments of every assignment, I get to be somebody else in their life. So one of the reasons I think I'm here today is that, as Terry mentioned, I served as the president of ASMP, which is a trade association for professional photographers. Our history goes back to the early time in life photographers that you probably recognize their pictures. And it's a rights organization. And so we educate photographers, we advocate in Congress and with publishers for photographers' rights. Some of those rights include copyright. Some of those rights include rights of privacy and also trademark, and all those things that Dale will be talking about. So I did that, and it sort of led me, the combination of being excited about photography, interested in teaching, and this sort of interest in copyright. I lecture around the country, and I talk to visual artists. And I used to talk about, primarily copyright and sort of these sort of nuts and bolts issues, and it sort of segued into, how does an artist sustain themselves today? And I think that's where the conversation gets really interesting really quickly. And if there's an opportunity, we can talk a little bit more about that. I think that's a good conversation to have. This is one of my most famous clients, Mr. Rogers. My work is both in the corporate realm and also in museums and galleries. This picture here of downtown Pittsburgh was actually featured on the front of a museum, which is pretty cool if you're a photographer, to have your picture 30 feet tall. But as you said before, I love photography as an amateur. This is my daughter. And I am a prolific iPhoneographer. And I also participate in the social media space. These are some of my iPhone photos. But I'm available at the Visual Raconteur is my Tumblr account. I'm on Instagram and IM. And I welcome you all to follow me. If you can find me, Richard Kelly Photo. I think that it's like I said, it's a really exciting time for photography, and I really try to enjoy it at every level. This is one of my teaching sessions. So as I mentioned, I've been featuring these topics, sustainability and copyright, in a couple of different lectures around the country. These are all available online at the asmp.org website. And I was also on a webinar with Harvard professor Larry Lessig discussing the future of photo sharing, which was a fantastic conversation. So just a couple of things I want to mention before I pass it on to my fellow panelists are, photography tends to be in the news a lot when it comes to copyright, and primarily around the areas of fair use. And I'm by no means an expert, but I think it's important to remember a couple of things, if you will mind going back in history with me for a second. Photography was really created initially as a source for artists. When I say artists, I mean painters and people who were doing drawings. So this is a camera obscura, and this was a means by which artists could do drawings and scale of the world in front of them. And it was later in the mid-1800s that photographers started to fix images onto paper. So if we think about that for a moment, I think it helps the conversation of what photography means to the world, but also what it can mean to each of us. It starts out as a source of documentary, and then later in the history of photography, it becomes more of an art in itself. So we're no longer talking about just capturing what's in front of us, but transforming it into something else. And there's some famous cases where transformation becomes integral to the conversation. This is the Rogers Coons case, where there's a postcard of a couple with their puppies that was turned into some sculpture. I guess we could talk about that at some point. This is a little hard to see, but this was also a pretty famous case where a photograph of Demi Moore was then parodied by, I guess it was Paramount Studios. So these are some of the, I think, the big cases within at least photography. And this is more recent. I think this was just settled this week, and that was the Sony case on the right. And I believe that, Dale, you may correct me here, but I think this was a...
The court recently found that the one on the right, which was used in the film, which was similar to the one on the left,
Right.
was not copyright infringement,
Right.
that there wasn't enough protectable expression taken.
Which I think actually brings up a number of key issues for those of us in the room who are interested in photography, and that is what is copyrightable in a picture. And even as a photographer, sometimes I'm shocked at what is not copyrightable and what is. And in this case, even though these pictures look very similar, the court said that the copyrightable aspects, the lighting, the composition, what the subject is actually doing, were, although similar, not the same. I think this would come as a surprise to many photographers. And in fact, there's a lot of chatter on social media right now about this case. Which brings up, I think, an important point I'd like to make, and that is that as I've studied some of these fair use cases, I think it's unfortunate that sometimes the photography is being decided by people who may not have that much knowledge about it. And I'm a little bit concerned. You know, it seems that some of the cases, even 5 years ago, already are out of date. They seem out of date to me. But, and of course, this is a Richard Prince photograph of a Sam Abel picture. And this is a Richard Prince version of a photographer who I know, Jim Krantz out of Chicago. So I find these conversations about fair use really interesting, and I sort of take my photographer hat off sometimes and try to imagine both sides. And I think it makes for a great dinner conversation, at least at my house. And so these are some more of the Richard Prince that's currently going on. That hasn't been decided, has it?
No, so just for people who may not know the case, on the left is a photograph taken by a photographer named Prince, who had spent...
Patrick Carew.
Carew, who
Yep.
had spent years living with Rastafarians. And on the right is one of the images by the artist Richard Prince that he made using those images. And the issue is whether it's copyright infringement or not.
I confess this was in my copyright exam last year, so some of the people in the room will have strong views.
Great.
Depending on what grade you gave them, at least.
So I just included my sort of favorites of the lectures I give around the country, because these are the kind of conversations that my constituency wants to talk about, and I don't necessarily have answers, and it does make for some great conversations. So I included them here mostly as a starting point so that when we go to the Q&A, we have something to talk about. So
Thanks very much.
I'm happy to pass it on to you.
I don't even know what to do with it.
Okay.
I'll just pass it back to Professor Fisher. I'm not sure. I don't really have any multimedia
power.
presentations. I should have listened to Richard when I was making my career decisions, because he chose to work with beautiful models. I chose to sit in a room alone for years at a time. So, you know, I started as a assistant DA in Middlesex County, which is where you're sitting right now. And at the time I was there, actually, Cambridge was the seat of the county. It's the main courthouse was in Cambridge. And so this was where I was trying cases. I was an assistant DA for most of the 90s. And, you know, I decided, we were talking earlier, I decided when I turned 30 that I would try to write a book. I never made the decision that I was going to be a novelist, which seemed outlandish to me. Even now it seems outlandish that I'm doing this. I don't think of myself as a novelist. I think of myself as a guy who's written a few books and continues to struggle to write books. But I don't, the term novelist implies a professionalism and a credentialing and a mastery that I don't feel, and that I don't know that any author feels. So I think I'm one of the few people who ever left the district attorney's office to take a pay cut. So, so I'm not sure that I'm the perfect representative of writers to be here speaking to you. But I can tell you that, and this will sound ungracious, but Professor Fisher asked about, what we as artists are thinking about, in the moment of creation and at one step removed when we're thinking about these sort of professional interests. And, to me personally, I'm not thinking about professional concerns at all, and I'm certainly not thinking about copyright or intellectual property. When you're doing it, you're in sort of a trance, actually, and the creative part of you is totally unrelated to the intellectual careerist part of you that's concerned with things like this. And to some extent, that's a function of the medium that I work in, which, unlike photography and unlike music, where this has been really a live issue, people use books differently and they use novels differently. I know that you've had some experience with novelists, but to me it's always seemed strange that, and not strange, but distinctive, that you don't need to own a copy of a book to enjoy it. There's less incentive for end users to make illicit copies and to borrow from these copies than there are in other media. And everyone in publishing is terrified after the example of what's happened to the music industry in the age of digitization. And, people simply consume books differently. And so, to me, the concern with piracy and stealing is less of a live issue. It's always seemed strange to me that everybody get very agitated about people, about the unauthorized use of music and the unauthorized copying of music. And meanwhile, we build libraries precisely so that people can read novels without paying for them. And then they charge novelist taxes to pay for these libraries so that people can take my book. And so that's, it's just a function of how people use the medium. The fact is, even if you love a book and if you intend to read it over and over again, you don't really need to own it. And I think even all of us who are in the room who are book lovers know that there are books that you want to own and that there are books that you just want to read on the beach and be done with. And you don't need to actually own the physical object. So that's kind of where I come from. When you're doing something like this, where the chances of success are so small, the remuneration in most cases is inadequate, and where the time horizons on each project are so long that it's a big roll of the dice to put this much time into it with such an uncertain payoff. You have to be driven by passion. You have to be driven by your own internal desire and your urge to create. And so, you're not thinking about these sort of professional interests, although, and this, is maybe the payoff for a successful, intellectual property regime, we're able to put those concerns out of our mind precisely because the system is working well. And that's, that's a relaxing kind of thought. I can put that out of my mind and just worry about creating what I'm trying to create. So, the only other thought that I would leave you with is I think that when we talk about intellectual property, when we talk about copyright, there's so much emphasis on protection of that IP and restricting these, the trafficking in these works and in these ideas. And, that's not the way books work. And to me, it's not the way ideas work. And so when I write, I am constantly aware of the tradition that I'm working in and the conversation that I'm a part of. I'm constantly borrowing, I'm constantly being borrowed from, and I want those ideas to move. I want them to move through me, in and out of my work, and I want my books to be a part of that conversation. So while I'm very happy that my books are protected and benefit from this whole regime, what I want really is a readership. I want my art to be seen, and I want to create freely, and I want people to be a part of that conversation as well. And so I think that when we talk about IP, we should really, I think sometimes we overemphasize the downside risks and, you know, the countervailing concern for that vigorous free market of ideas and for the free movement of ideas is something that I think we pay too little attention to. And particularly the corporate interests who can, you know, hire fancy attorneys and who can drive this whole process, you know, will always have their voice heard. And what's important to me is that, you know, the other side be considered as well. And that the public interest in sort of keeping these ideas moving, keeping books passed around, keeping ideas being passed around is equally important, at least to me. So that's my 2 cents, and I'll pass it on.
Excellent.
So hey, I'm John, and actually that's a really nice segue into sort of how I was going to talk about stuff. I'll keep things really brief because I want to make sure we get to hear what you have to say.
That's why I'm here. I'm just setting you up.
It's great. Yeah, it's a good opening, good warm-up act. I guess the difference between what I do and what you guys do on some level, although obviously there's collaboration in every field, is that the industry that I work in, video games, is primarily an industry where one person can't really represent the work of an entire team. The company I work for, Harmonix, we're based in Central Square, right above the Walgreens, is actually a company of about 250 people. We're currently working on 4 or 5 projects. Every game has artists and coders and testers and producers and designers and executives and a lot of lawyers. At the end of the day, we're all kind of making something together. And really, one of the things I think that's different about that is that almost, not overnight, but in comparison to the duration of photography or writing, almost overnight, very much video games has become an industry. It's about companies that have corporate interests and are, you know, making big projects. And while there is a really vibrant and awesome indie game scene of small teams making things for themselves, mostly as a personal pursuit or as an artistic pursuit, on some level you have these big companies making multimedia creative arts, which is super weird. And from my perspective, one of the things that's been recently kind of happening is the industry has been fracturing into 2 big groups. One of those big groups makes games like my company makes, which is thought of as the AAA game space. It's these companies that invest 20, 40, 60, $100 million into a franchise. They build intellectual property from the ground up. They do a ton of research. They spend 3 years on a project. They release it, and either it makes a ton of money or that company no longer exists. And sometimes that company no longer exists. And those are companies that are usually fiercely invested in making sure that they have the rights to their stuff and it appears the way they want. It's distributed via their channels without piracy. On the other side of this, there's a new sort of cottage industry springing up around mobile and social. Most people in this room are either holding a smartphone, sitting on a laptop, or currently on the internet, where they could also be on Facebook playing Farmville while we're talking. Don't, though, listen, because we're saying important things. And that industry is really built around a different model. It's not about acquiring a customer to give you $60 one time. It's about giving someone a taste of something, you could call it the drug dealer model, and then getting them to give you money over and over again once they've had that taste and they get hooked. And in that industry, a lot more, it's about really, it's a business philosophy called chase or kill. So you make something, you make it quick, you make it dirty, you make it messy, and you get it out there, and if people fall in love with it, you put as many resources behind it as possible, you make it as big as possible, and you get as many people to give you money as possible. Or if it doesn't do very well, you didn't spend that much money on it in the first place, you kill it and it goes away. And that's a really cool way to make little games. We call it rapid iterative prototyping, and maybe you find something that's really hooky and it's a new thing and that's phenomenal. It's also a really good way that you could chase your own ideas and your design mechanics and your dreams, or you could just chase, like, you know, what the other companies are doing and maybe make games that sort of feel very similar to other games that are already in the marketplace. And there's been some really interesting cases lately between companies like EA and Zynga and a small company called Nimblebit and Zynga, a lot of companies, a lot of suits involving Zynga, about game ideas that seem to be lifted almost wholesale. And so the question that comes up in our industry a lot in dialogue is that we are very much, to the point you were making, a discursive industry. It's actually pretty small for how big the sector is, and people are talking to each other, they move jobs a lot, we learn from each other in a lot of ways, and there's only so many things you can do with a character with a gun, so you sort of start making the same game over and over again unless you innovate. But at the same time, when are you copying the essence of a game? When are you bringing over the entire game wholesale? When are you taking lines of code and you can prove in a court of law with a lot of expensive lawyers that this game was stolen versus, well, it was inspired by, it's an homage to, and like, at the end of the day, aren't all games just Tetris? So my Tetris clone has been taken down off the internet thanks to Dale. But yeah, it's possibly true. So last and not least about the games that we make. So I work at Harmonix. We developed Guitar Hero. We created Rock Band. We created a game called Dance Central. So we make really authentic music games. I was a musician. I'm in a band. As your professor nicely said and plugged, thank you for that. I was hired because I played the drums. I needed someone who could break drum sets by hitting them really hard. And that's a skill that I have because I have a degree from Harvard College. So I learned that practical life skill. And we make games that are sort of recursive in their own right. We make games that are derivative works of other people's music. So we need licensed music from big acts to fill our games and make them interesting to fans that they want to be marketed and sold to. Which means that I run into a lot of things as someone who works on promoting those games and also developing and helping with the design of some of those games about how we can expose those games to lots of people without offending our 5 major label partners, and what kind of rights do we have to say someone's name? Can we say that we can't say that this artist is in the game? We can say a songs by an artist are in the game as long as we list 7 artists when we're talking about how many artists are in the game. So these very, very elaborate rules that are all about relationships, which are all built upon a foundation of copyright law at the heart of it, and intellectual property law. So our games are sort of a weird mishmash of creative, new multimedia that we design and feel really passionately is unique and authentic and awesome, and at the heart of it is like 45 songs by the Beatles that you already know that we did not write. I wish we had written those songs. So that's kind of my spiel. Super interested to talk to you guys and hear what you have questions about, but glad to be here. She's going to walk around.
I am too short to sit comfortably on this chair, and I'm surprised Dean Minow allows chairs like this at the Harvard Law School. Let's see. Can I have the clicker?
You can.
Terry, all right. So a couple of disclaimers, because I'm a lawyer. I'm going to be talking about rights of authors as reflected in some of my cases, but I'm only going to be talking about things that have been expressed in actual briefs or on testimony. So I'm not waiving the privilege here, okay? Second, while I will tell you where applicable what happened in some of these cases, just because it seemed odd to not tell you the punchline, this is not the course to talk about in depth all the rules of fair use and all the rules of copyrightability and all the other rules that I'm sure Terry's going to teach you at different points in length in the course. So I'm just going to be focusing on what were the interests and concerns of the artists in these cases, and how was that expressed in an actual litigation. And it seems, since of our esteemed panel, it would be good to pick cases about book authors, video game authors, and photographers. Go figure. So let's start with book authors. And let's talk about a pretty successful one, J.K. Rowling, who is some of my students from my class I teach in the fall are here. People know I have a particular affection for. This case, this is a picture, a licensed picture, by the way, of J.K. Rowling testifying at trial in New York on the Harry Potter lexicon case. And what that case was about is that there was a website, that was a fan website that had lots of content about Harry Potter essays and the like, and someone said, let's turn it into a book, but let's not have all the essays published, let's just have A through Z listings of everything that's in the Harry Potter books, all the people, places, and things arranged alphabetically and recast in this book without a lot of explanation. So there would be lots of what we believe to be verbatim copying. So if there was the Hogwarts School Song, there'd be the Hogwarts School Song. Or if in Deathly Hallows, J.K. Rowling would write about goblin-made armor and imbibing only that which strengthens it, without quotation marks, they would talk about the same thing and about imbibing only that which strengthens it, without a lot of analysis about what that means, what literary significance there might be to that term or something to that effect. And in particular, there were many, many entries taken from 2 very slender books that J.K. Rowling wrote for charity that were essentially completely taken and restated in this book. So what happened? Why did J.K. Rowling file the lawsuit? What was the concern about it? Well, it wasn't about the money. You know, this wasn't about how can I get more money or this would stop me from getting money or anything like that. It was about, as she testified, concern that all the highlights of her work, as she put it, all the plums in her cake, were taken without her permission, and not anyone talking about it, just sort of taken and recast with somebody else to make money. And that all of her narrative twists and distinctive phrasing, all of that was taken without any quotation marks, and the only thing that was interesting and entertaining about it was the stuff that she wrote. She was accused of having been too tough about, oh, you shouldn't stop people from writing about Harry Potter. But she said, no, I'm not trying to stop people from writing about Harry Potter. It's great that people write about Harry Potter. And in fact, it was good that someone, the other side, accused us of that during the court, because these are actual trial exhibits, because we're able to show that there are many, many books that J.K. Rowling did not have any problems with, like books about Harry Potter and religion, Harry Potter and literature, Harry Potter and kids, Harry Potter and science, Harry Potter and business, Harry Potter parodies, other encyclopedias of Harry Potter, many, many, many books about Harry Potter. But those books took less of her work, used quotation marks, and did more with the work, added more analysis, value, thought, rather than simply taking and using a word processor to recast the books. And that was the difference to her. She also testified about how copyright was an incentive, that if when early on she did not have the means that she has now, if when she was at times literally choosing between food and a typewriter ribbon, I had been told that I did not own these words, that these words were not mine, that they could be taken, lifted by anyone, and resold under a different author's name. That would have been devastating. And she also reacted to part of the comment was, oh, well, you know, the Harry Potter books are so popular, so what? I mean, you can't be hurt. It doesn't matter because the Harry Potter books are so popular. And she said it would be a shameful thing. It would be bad if copyright law were interpreted in a way that just because someone wrote something that was successful, that person would have fewer rights because of that success, because they did something that people liked. And here is a clip from her after the trial one day, which I hope will play shortly.
It gives me no pleasure to take legal action, but I'm here today because I feel very strongly about an issue that affects many more people than just me. If books that plagiarize other works are permitted, authors, fans, and readers stand to lose. There are lots of books in many languages that comment on or criticize Harry Potter, and I'm delighted about that. But the book in this case is different. It provides no analysis and virtually no commentary. It takes far too much, and it gives far too little.
That was our trial theme, by the way. It takes too much, and it does too little. So what happened at the end of the day was that the court found that there was copying, that it was substantially similar, and that the fair use doctrine did not excuse this book from, to permit this book to be written. And you can go back to these slides and look at it more. The court agreed with her. It took too much and did too little. But no, so now let's talk about video game authors and some of the things that they have said. Something we've talked about a little, and let's talk about the Tetris case. And here, there was Tetris. How many people recognize Tetris here? You recognize it? Okay, all right, good. You know, studies have shown if you play Tetris, you get smarter at math. True. So it's probably a lot of people from Harvard played a lot of Tetris. Okay. And then on the right is a game that recent graduates from, not from Harvard, from a different college, made called Mino. And Tetris said stop, and they said no, and a lawsuit ended up happening. So I'm not going to talk about all the details about the lawsuit, but part of it was that there was a feeling that video games shouldn't have the same rights as other kinds of works of art because they're made by computers and that they're somehow functional. Part of the defense was, you know, this is functional. Tetris really can't be protected by copyright. It's really just a collection of rules. Maybe you can patent it, but it's really not something copyright law can protect. And from the client's point of view, it was video games are art. There were creative choices. We make creative choices. The video game should not be relegated to a lesser status. And the other thing that they were really upset about is Tetris was originally created by a guy named Alexei Pajitnov in the Soviet Union, and Hank Rogers, and a guy who's kind of kept it current and revitalized and has created many, many games over the years. Their attitude was very much, I don't get it. These are young guys right out of college. They should be making new things. They should be making Rock Band. They should be doing new things. Why do they feel that they need to like copy Tetris and have that be their claim to fame? Like, don't kind of destroy my copyright. Come up with your own thing to copyright it. And that may not be the world's best legal argument, but that was what they were thinking and was reflected in our litigation papers and the like. Don't say this isn't copyrighted. Come up with your own thing. Be innovative. And ultimately, what ended up happening is the court agreed with Tetris and found that Tetris was copyrightable, that Mino was substantially similar. There was also some trade dress issues that we won on, and ultimately the game was enjoined. And now let's talk about photography. And one of the great things about Harvard is that this is a case where not originally, but ultimately, Terry and I were on opposite sides on. And so it's nice that we can talk about such things because it's just because you're on the opposite sides as lawyers, it doesn't mean, I mean, you're not supposed to be the client, you're supposed to just represent the client. And that's why people are able to have an intelligent conversation about these things. And I'm not gonna get into the depth of it, but this case that I want to talk about was the Associated Press versus Shepard Fairey. On the left is the photograph made by the Associated Press's photographer, Manny Garcia. And I note, did you notice when Richard was talking, he talked about making pictures? One of the things that I learned was that photographers talk about making photographs, right? Not taking photographs, because taking a photograph suggests that there's this fantastic photograph just sitting on a shelf somewhere and you just need to take it. When the photographers have a different view. Their view is that if it wasn't for me capturing that time, that moment, that composition, that lighting, it would not exist. So a photograph is made, not just found. And that was a fundamental difference of opinion in the case. So what the case was about, in simplistic terms, is an artist, Shepard Fairey, chose an AP photograph to make the Obama poster. No credit was given to the AP or the photographer. The poster was offered for free download, but also for sale in various different ways. And the AP depends on revenue from licensing. And this was a trial exhibit. Let's see if this works. Which, you know, in our mind, showed a lot of similarity. Let's see it one more time, just because I like it. That's one of the things I like about teaching. I can do whatever I want, and they have to sit there. Anyway, so one of the themes from an artist's point of view in the case was the idea photography should be respected. It shouldn't be a lesser art. And that theme is infused in a lot of the case, in a lot of my cases, because sometimes there's a perception of high and low art. That artists like Richard Prince, they're great. They're real artists. They're like in big galleries, and you can pay $10 million for them. While photographers, you know, they're kind of low art. They're maybe a step up above comic books, which I love, but they're kind of low art. Only when someone who's a high artist comes and makes a blow up of a panel of a comic book panel, then it becomes high art. But before that, it's low art. But copyright law isn't supposed to differentiate between the types of art. And so part of the concern was photography should be respected. And one of the things in this case that was very frustrating for the Associated Press is many people, not so much Terry, but many people, commentators about the case, said, it's just a mugshot, it's just a mugshot, it's not a special photograph. Except Shepard Fairey, the artist himself, said, I chose it out of hundreds of other photos that I looked at because I wanted something that portrayed the then junior senator from Ohio as a man of vision and leadership, with a particular look to his eyes, similar to that Kennedy and that Che Guevara photo of looking forward and upward and out and looking like a leader, as someone that you might have hope in. So to have people say, oh, it was just a mugshot, when the own person said, no, it was more than that, was frustrating to the AP. And then the other thing was licensing. From the AP's point of view, it could only exist via licensing. The Associated Press is a not-for-profit news collective. That means at the end of the year, various members who are newspapers and media institutions divide up the cost, and that's how it stays in business. And it provides news stories and photographs all over the world. And because there are fewer newspapers nowadays, it's harder to stay in business, so they've engaged in licensing in order to help grow the business. They've told their photographers, bring me things for our photo archive that we can license and make money on. So if they couldn't license them, they wouldn't be telling photographers like Richard, go make them, and there would be fewer photographs, less art. And that was very much on their mind. They ultimately felt, as I conclude here, they ultimately felt, and we said this in our briefs, that there should be a symbiotic relationship between first artists and second artists. As Shepard Fairey admitted, he doesn't have access to world leaders. He couldn't get the even then junior senator to sit down and pose for him. So it was great for him that there was somebody like the AP making these photographs. And maybe you could argue that Shepard Fairey created a beautiful image and that he did something good too. And that's great. But who should get all the credit and who should get all the compensation? Should it just be the second artist or should it be the first artist? The AP's position was it should be a symbiotic relationship. Everybody should share the credit. Everybody should share in the proceeds. Ultimately, we settled with Shepard Fairey with his licensee, Obey Clothing, which made the T-shirts and the like. They didn't settle. There was a motion for summary judgment, and we won on summary judgment, striking the fair use defense. And once the fair use defense was struck, the case soon settled, and it's over. But that, I hope, gives you a little bit of a flavor for how, when you're representing authors in actual litigations, of some of the things that they care about and where they draw the line on what's okay and what they think is a taking of their work.
Thank you. Wonderful. Okay, who wants to start? Allison, you got one from the edX group.
I do.
Okay.
So my name's Allison. I have a couple of dozen wonderful students online right now. And I've just asked them to shout out what time it is, and it's all through the evening. I see, 1 a.m., and I know for some it's 8 a.m. So thank you for a talk that's compelling enough to keep people literally awake. Really appreciate that. And there's just so many questions. I'll just choose one that they've kind of come up with. You've all rightly mentioned a lot of professional work and the conversation around that, but many of my students are amateur photographers, and they're interested in our new sharing culture, specifically Pinterest. So taking professional work and sharing it, maybe remixing it in their own, but then also they're interested in them putting their work online and having it used by major media outlets without credit or payment. So I'd love if you could speak to that. Thanks very much again.
Well, you really get to the heart of it right away. Sites like Pinterest are a big topic in my tribe these days. I think the big issue is attribution. In the social realm, that seems to be lost. The technology companies don't necessarily see value in connecting the work back to the originating source. And so I think for whether I'm an amateur speaking or I'm a professional speaking, that disconnect is important. I think that's one of the areas we can work on with the technology companies is how do we maintain that attribution? Because at the very least, that should be included. Because if there's attribution, then at least there's some other social media value to me, whether I'm an amateur or a professional. I want to take credit for the work I create. I'm not so sure we have an answer to all of the questions that they've posed there, but personally right now my focus is on how we can build that attribution connection from the technology that's out there. But at the same time, I actively am in the social media because I think it's important for, it allows me to connect to people who care about what I do. So I'm kind of on a balancing beam. I would like to mention one thing is sort of on the side, I've been working with media companies and technology companies on intended licenses, licensing with intent, meaning that the artist or whoever's creating the work is telling the world what you can do. And so one of those formats is the Creative Commons format, where the artist decides, this is how you can use my work. And I think that there's something there for some of us.
Great. Okay. A real space question. Rebecca.
Hi, and thank you all for coming. Mr. Landy, this is a question for you. I personally write a lot, and I'm just very curious. You mentioned there's a very big difference between authors and other types of artists when it comes to the new technology around today. Do you think that authors have the potential to have an untapped resource in the internet that they're not using as much as other artists are, or do you think that it would be detrimental to the copyright intellectual property if they were to expand more like musicians and other artists have?
I think both, and I think it matters, you know, how you're using the internet. I'm not sure how untapped it is at this point, but you know, I think that one of the great problems for authors is the same problem that musicians have faced and largely lost the battle of how do you monetize the prose that you put out on the internet that gets passed around. You know, the great fallacy of this is that now there are fewer barriers to publishing. Everyone is a publisher because everyone has access to the internet. The problem is, first of all, making money from that. It's a very big, noisy marketplace, and simply to you know, put up an EPUB book on Amazon, for example, is very unlikely to yield enough income to make it worthwhile. You know, everyone focuses on the success stories. You know, people who sell a book for 99 cents or $1.99 and get wealthy that way. That is a vanishingly small minority of those books. So, you know, to that extent that you're using it as a publishing platform, honestly, I still think that the traditional big six, you know, the gateway publishers who are supposed to be the dinosaurs that this asteroid of the internet is about to wipe out, you know, they're still where it's at. And I don't anticipate that will change anytime soon. And, you know, to that extent, it's not really an IP problem. The big problem with digital, as it was with music, is really an antitrust problem. You know, musicians lost because Steve Jobs was able to establish a monopoly on the sale of digital music over the web. Amazon is really trying to replicate that right now, and they're winning. You know, Borders is gone, Barnes & Noble is teetering. There are many, many fewer independent bookshops than there used to be. And so this whole ecosystem that used to support writers, and particularly mid-list writers, who, the publishing industry at one point would support through, books that sold in small numbers for 2 or 3 or 4 books, and finally the 5th or 6th book would hit. That's getting very, very difficult to do now for publishers because it was always a low-margin business, and now it's a no-margin business. And so what you're seeing is the same kind of economics that have shown up in the music industry, where it's for the haves, for the big acts, there's always room. There's always room on that front screen of the iTunes store. There's always room on the front page of Amazon for John Grisham's book. Very hard for an unknown author to break through. In fact, I had a big book this year, but it was my first breakout book, and one thing that was surprising to me was how grassroots the effort was to build that book, and how many things the publisher did out of sight and offline that contributed to this sort of bottom-up marketing effort. And so, I think the mantra now is that the web is the be-all and end-all, and it's likely to end up that way, but we're not there yet. So my advice is establish yourself quickly before we get to this new regime where, only U2 and Bruce Springsteen can make it, or whoever the U2 of authors is.
So one of my students asks about the issue of fan fiction, such as 50 Shades of Grey, and wants to know what about people that are creating adaptations of novels by avid readers and fans, and people that are encouraging the creation of these adaptations. How should they be treated?
Well, legally, I think most people would agree that fan fiction would be copyright infringement. Technically, it would most likely be seen as a derivative work. Somebody has created a world and someone has made fan fiction based on that world, and that would probably be copyright infringement if anyone ever wanted to litigate those cases. But most authors have the attitude that they're not going to litigate those cases because as long as someone's not selling the books, most authors feel, you know what, it's great that fans are out there talking about it. J.K. Rowling testified in the Lexicon trial that she loves the internet. She doesn't read fan fiction. She doesn't like fan fiction. It bothers her, but she sometimes hears what people want to do with her characters. But that's okay. But most people draw the line when it comes to someone actually, you know, selling their own Star Trek novels or their own Star Wars novels. That's what crosses the line. Although I will say that there's some authors who have a different point of view. I mean, famously, Anne Rice really doesn't like even the fan fiction. I don't know if she's ever brought a lawsuit, but she did that. And I remember even further back in the day, as a Star Wars fan, it used to be known that before there was the internet, really, there were a lot of people who would do Star Wars fan fiction that had Luke and Leia going off into the sunset and getting married and the like. And George Lucas was really upset about that, and those people got a lot of cease and desist letters because he knew what the story was.
Now that Disney owns them, I'm sure there won't be any more cease and desist letters about Star Wars there. Should be fine.
But Dale, it's not always because of the. It's not always because of the money. I think sometimes it's because the passion you put into your product or your book or your photography, and you don't want to see it distorted in some way. There's, you know, as artists, we're very connected to what we create, and so I think that a lot of times when these issues come up, it's emotional. It's an emotional, not just a legal thing.
Yeah, building on that, I mean, to me personally, one of the hardest issues in copyright law is the person, the first author, that wants to say no. I mean, J.D. Salinger famously has said no in different ways. I don't want my letters published. I don't want sequels written. I don't want you to do things. And for some authors, you know, the idea that someone could, you know, you're not doing Calvin and Hobbes anymore, I should get to do it. You know, they wouldn't have done it in the first place if they thought somebody could take it. The right to say no is something that artistically matters a lot to authors. And in the United States, where we don't have the same strong moral rights that exist, for example, in Europe, there's a little bit less of that here. But this integrity matters to some people. And that's one of the reasons Anne Rice, famously, she's not one of my clients, has not liked it when people would do fan fiction, because in her mind, her characters react a certain way, and they don't react the way that that person's writing.
It would have been interesting in the Shepard Fairey case if the photographer had been a hard-right conservative who objected just on emotional, political, intellectual grounds, saying, I don't want this to be used because I disagree with the statement that you're making about Obama equaling hope.
Well, you're right, and you see some of that in, not so much in taking a photograph and making a poster, but there have been a number of lawsuits where someone has taken music and just used that music in a political campaign, and the person whose music was taken said, yeah, I don't want to vote for you. I don't want you to have my music associated with that.
Although, wouldn't they be able to license it?
Well, they are claiming it was copyright.
I'm guessing that sometimes when you see it as a news story instead of legal actions because a publisher and a label said, yeah, sure, we'll take a couple $1,000s to use the song, and then the artist found out and was displeased personally that it happened.
Right,
Yeah.
right.
Gotta make a buck.
So I want to pick up on that theme for just a moment. Richard, your question nicely reminds us that from a technical standpoint, copyright law is riddled, would put it too strongly, but has lots of compulsory licenses built into it. And among the contexts in which that makes a big difference in terms of creativity and control of the sort you're describing is the music industry, where in some contexts, artists, once they release their stuff out into the wild, cease to have that capacity to say no. And one of the, sometimes. So one of those contexts is a composer who consents to the commercial distribution of a recording, thereafter has the right to collect money when other people want to make covers, but no right to block it. Now, this raises a variety of problems, but there's a narrow one for the music industry that none of you were directly in, so this maybe requires some projection on your part, and then there's a more principled issue. So here's the one that's the music industry. It seems that composers have adapted to this environment. You don't see a lot of protest marches or lobbying for the right to stop covers. We just accept it as, you know, the way things are done. I don't like the way in which X did a cover of my song, but okay, it's life. So that then leads to the more general question is, are artists' expectations about control contingent upon the legal environment in which they find themselves, and if they don't have it, they lose the desire for it? Or are they sufficiently deep-seated that it will be a continuing source of pain to witness your work applied in a way that you find noxious?
There was really recently, on the music tip of that, I'm not sure if you followed the Jonathan Coulton Glee fiasco that kind of went down, which is named...
Explain it a little bit.
Oh, sure. So Jonathan Coulton, who actually is a friend of mine because he's also a big nerd who likes video games, created a cover of Sir Mix-a-Lot's classic tune, Baby Got Back. In sort of a hyper-harmonized style, he licensed the right to use the cover and to distribute it. He put out a record with that on it, and it was on digital up for sale and things like that. He used the lyrics, but the arrangement was entirely his own. Glee, I think 2 weeks ago, maybe 3 weeks ago, basically wholesale lifted his arrangement of the song, which was not in the original recording that they presumably went and got the rights for. And when he sort of heard this from fan blogs saying, hey, this sounds exactly like your arrangement, and when you line them up, they are almost identical. The audio is not directly lifted, but the arrangement is almost identical. Glee basically told him he should be thankful that they used his arrangement. It's good exposure for him, despite the fact that he wasn't cited or credited, and there's really nothing he can do. And after talking to a bunch of lawyers, it seems that there sort of isn't very much he can do because his arrangement's not protected by copyright. The original recording, the original master would be if they use his actual sound samples. And he seemed, from a legal perspective, pretty upset, but without a lot of recourse. But from an emotional perspective, he seems incredibly frustrated. Like, this is a lot of work that he put out there. It's a thing that he's pretty well known for as an internet, YouTube video style thing that he went out of his way to license, and someone lifted it wholesale. At the same time, he also licenses recordings under Creative Commons. That's what my band has done in the past, sort of an attribution, non-commercial, Creative Commons license where you want people to share your music and to remix your music. And I've had some really bad remixes of my music sent to me, and I would never tell someone to take it down because it's as long as they're setting our band correctly, it's more people who have heard about our band, who maybe go and listen to the source material and say, wow, that's a really terrible dance hall remix of a pop song that I actually do like, and I will download that original pop song. Don't download the dance hall remix, it's really bad. So just an interesting, to your point, like the heart of the matter is not really covered by the copyright law that sort of the foundation's built around, even though he tries to operate in that sphere as well.
I once asked an attorney for our AS&P group if he thought that our members were more interested in control or money. The control you're talking about or making money. And he said it depends, being a good attorney. But I mean, I guess, because I have a lot of friends who are musicians and we talk about this sort of thing a lot, I guess I'm willing to allow a certain amount of use for money, even if I don't have control over it. So just send the money and I'm happy. So I'll give you my address later.
Seriously.
So this relates a bit to the answers you had just given. Under the various theories of copyright law, particularly instrumental ones, but also probably the moral rights-based theories, I think it's important for us as lawyers to know whether and how you might, as artists or authors, have misconceptions about what copyright law provides and doesn't provide. So it would be, I'd be interested to hear some of the, if you have had any misconceptions in that sense about what copyright law does. You thought it provided something but didn't, or vice versa.
I guess that without speaking too much to like legal matters that are ongoing for our company, there have been a couple games, especially in this dance game space. So we make a game called Dance Central. It's for Kinect. It's this 3D camera that can see you dancing with no controllers. It's pretty cool. It was pretty innovative when it came out. It was sort of the game for this new device that it came out, and people were really excited about it. And then a year later, there were some games that sort of had elements of our game sort of woven into them, and then the year after that, there were a lot of games that had elements that had kind of been piecemeal lifted, but none of them were really the heart. And it seemed to me, you know, I went to a show floor in Germany, and I walked around one of these big video game expo halls, and I saw a game from a pretty major company that looked like it had taken major elements of our game and sort of had built their entire game around it, maybe even some source code that they had gotten somehow. And so I'm texting our lawyers furiously like, they're ripping us off. Like, this is the game that we invented. Like, we worked really hard on this. People respect us for this. It's what we do. And they said, yeah, maybe. It's mostly a look and feel case. Like, the chances of us actually like going to litigate or see if we can get some money for that or stop that game from coming out from another like big publisher, it's not really a thing we're ever going to go after, because it's really hard to prove that it wasn't just, you know, this is how dance games are expressed, and it's not the Tetris mechanic, right? It's not the, oh, it's these pieces, these tetraminos rotating in this way, falling towards the bottom of the screen, doing exactly that. It's like, oh, it's if you use Tetris shapes, but it was a completely different gameplay mechanic. So I always thought that we would be super litigious and go after everyone who stepped on our toes, but in fact it was like you kind of can't chase every thief as they run out of the bank with a small bag of money. If they take a big bag of money, you can probably tackle them. But.
Well, if I can, maybe there's been a few times where, not just myself, but when photographers call me, and usually they have this case that, you know, they've discovered of someone copying their work. And I think for photographers, copyright falls into kind of two categories. One is when somebody takes the actual image and then uses it in some way, or they take elements of a picture and they recreate it in their own picture. And this is where it kind of gets interesting, because as I pointed out in the one picture of the Sony case, is that there are only some things that are really copyrightable. And when I tell photographers that, usually they're not happy, because they sort of expect that they can copyright everything. And there are just some things, especially certain postures that are natural and people's faces and things like that, that just aren't copyrightable. And I think there's a lot of confusion between an idea and the fixation of that idea. And so a lot of the lectures I do to photographers are to kind of educate them about what in fact they are creating and what they are in fact protected by under copyright. But a lot of the phone calls that I get are emotional phone calls. They feel they're being ripped off.
Yep.
And I will tell you, the biggest, if you have clients, and this is something you're going to face, is it's the therapy of walking them through that this is not the most important thing in their life. Now, it could be important, Dale, right? It could be important, but some people, some artists get to the point where they can't create anything new because they're fixating on this one thing. And it's, I've seen photographers just freeze up.
Well, there is a lot of misinformation, and there's various volunteer lawyers for the arts and groups like that, the Comic Book Legal Defense Fund. There's organizations out there to try to help people know about rights, but I've certainly discovered that in the entertainment news media, there's urban legends about copyright that exist, that the in-house lawyers and me sometimes as the out-house lawyers are always hilarious about, but the seconds vary, but there's this urban legend that you can take 7 seconds of anything and it's fine. It's like the equivalent, the copyright equivalent, if it drops on the floor for 5 seconds, you could still eat it or something like that. And no matter how often you say to people, you know, if those are like the top 7 seconds of that Zapruder film, not that that's a particular issue, or the Reginald Denny beating, or lots of other different kinds of important things out there, the heart of the work, that could be an infringement. It doesn't matter if it's 7 or 5 or 8 or 12 seconds. But there are a lot of things, and the reason I'm mentioning this is A, that there are these things, and B, I think it's because when people are doing these things, they can't always have a lawyer sitting next to them. So they've tried to develop kind of sensible kinds of rules that they think makes it be able to process the day and get through things. And some of those rules actually mirror law, and some of them don't.
Charlie.
Great, thank you. So I'm representing Section C1. We are equally scattered across the globe. And I wanted to ask one question here synthesized from my group. Early in the session, Richard, you mentioned or made a comment about courts making decisions without knowing anything about photography. And similarly, Dale made some comments about high art versus low art. We've learned in this class, both at the Harvard class and in the online classes, that courts should at least strive to be aesthetically neutral when they're making their judgments. Do you think they're meeting that aspiration? Is that impossible to do? Are there systemic biases in the copyright regime? You know, basically, can you clarify your position on that issue?
I'm not an attorney. I don't play one on TV. But you know, I spend a lot of time reading some of the, and I'm reading them as a layperson, as a photographer. It just seems to me that even within the United States circuit system, they can't agree on outcomes, and I think it makes it really confusing for us as citizens to understand what that means. And I don't have a Dale sitting next to me, and so I think that. I think that there are, you know, I have concerns about how some of the outcomes are being, the precedents that are being set, but you know, it's just me being cranky, I suppose.
I don't think that there's systemic issues on the part of the judiciary. I think the judiciary calls them as they see them. I don't believe that's the case at all. I guess I was referring to, you know, I've had a lot of cases where experts and the art world experts, et cetera, have weighed in, and that's a particularly big issue with regard to appropriation art nowadays. And there's differences of opinion people can have on that issue, and there are certainly those people who would elevate the second user's work without giving as much credit, something, to the first user, and that's what I was referring to. I wasn't saying that on the part of the judges I saw a particular bias, but the judges can only base their decisions on the input that they're given. So if you have lots of expert reports and lots of data that go, that say one thing, you know, that's going to be factored in.
I've got a question that seemed related to several of your comments earlier. That's going to come around to a question both for John and Dale. So here's the theme. A frequent observation in the copyright space is that there is a divide between creators and intermediaries. And often, Bill, to go back to your observation, there's concentration of economic power and lawyerly assistance at the level of the intermediary. And when that concentration gets high, artists are as disadvantaged as are ultimate consumers. And so the zone in which this problem is most often located is the traditional, not the current so much, but the traditional recording industry, and there are relatively few organizations, and 7, 6, 5, 4, who entered into exploitative contracts with most artists until they reach a certain level of stature, and then they regain bargaining power. But the narrative of powerful intermediary and disadvantaged artists is dominant in that area. And okay, so how's that relate here? Well, there's an accusation that comes out of this observation. The accusation is that the intermediaries appropriate the language of creativity, but actually they're not the creators. So the variant of this question for you is that some of your clients are intermediaries and some are creators. So J.K. Rowling is a sort of classic, super successful creator in your vein. By contrast, 20th Century Fox in the Daystar case, or the Associated Press in the Shepard Fairey case are the intermediaries. And in fact, back to your question, the Associated Press and the photographer, Manny Garcia, were opposing parties in the litigation. So the question for Dale is, does the language shift when you're representing artists or intermediary? A harsher way of putting that is, do the intermediaries appropriate to their advantage the discourse of the artists? Question for John is, you participate in an organization that is sometimes held up as an exception to this pattern. Small. I mean, you describe it several hundred people, but compared to 20th Century Fox, who are small, relatively non-hierarchical, this is at least the stereotype, you're going to correct me if this is wrong, and startup and feel. When people start moving around, and some of your own anecdotes suggest this, you were a drummer and then you become the face of the company.
Surprises me every day.
Yeah. So the way this is related to this general theme is sometimes said that this is a different cultural phenomenon that is not so easily characterized and criticized as powerful intermediary exploiting powerless creator. So first Dale and John.
I don't think that certainly 20th Century Fox or the Associated Press would think of themselves as intermediaries. And from the point of view of 20th Century Fox, similar to the video game model, you said it's hard for one person to make a movie or a television show. It's a collaborative process. And so you need somebody to pull it all together. And there may be more employees, but usually on a particular work, there's a smaller group of people that are doing Modern Family or doing Star Trek or whatever it is. That's not a Fox show, but that idea. And they see themselves as, I'm making choices. I'm hiring these people. I'm creating the team. I am the producer for it. I'm creative too. And I think that's how people see themselves. And the Associated Press, they absolutely are not the people making the photos themselves, although their employees are. But very much the ethos of the company is on the wall as you walk in are the names of the photographers and reporters who lost their lives covering the news. They see that as them and their culture. I would use the language of intermediary more to talk about some of the the internet folks that would be more like the Googles and things like that may not create content really at all, but are the beneficiaries of content.
Well, that's super interesting, because maybe intermediary is a sort of semantic issue to contend with, but at the same time, like a Google or an aggregator at the end is much more an audience and a director of audiences to a piece of content. And I guess in our industry, we think of it as developers, which is probably pretty synonymous with creators in the context of the work, and publishers. So these are the people who own the distribution channel. So as long as video games are physically distributed media, talking about going to GameStop or Best Buy and buying a $60 disc and going home and playing it, then a developer's job is really to make a game that is appealing enough that a publisher wants to invest in it and then own a piece of the IP perhaps. And that's sort of the old model. You want Activision to buy your game. You want Electronic Arts to buy your game and put it out to the world because they have the efficiencies in the market to put things on shelves, to put stuff in magazines and on television that you as a creator of your own media don't have. You work in video games. You don't work in print advertising or retail chain management. But that's changing a lot. And I think that one of the things we were talking about earlier is the idea of whether the internet can solve the book problem or not. And I think all of those things come down to a problem of discoverability. But as our industry evolves to a mostly digitally distributed model, whether it be iPhone apps or things you can buy on your Xbox just by hitting a button rather than going to the store, it seems to me that the industry is moving towards these middle-sized companies like ours that are trying to own their own IP. So we own the Rock Band IP. We were sold off from MTV. Viacom bought us in 2006 and then spun us off in 2011, and we retained the Rock Band rights, the Dance Central rights. So we own that intellectual property. And if anyone wants to come make a game with us, they have to deal with us. Like, we own that idea, we own the world around that idea. And I think that that's really where you see companies now, is you see developers who really want to invest their own money, if they can, once they've established some success, to own that IP wholly, and then go to distributors just as like a partner's deal to say, hey, we'll give you, some margin on the disc that you're selling, but in fact, like, you don't own the rights to this really cool platformer that I built that doesn't look at all like Mario. And I guess the point there being that you only go to them if you need them, and ideally you can work around them and retain. I think the long-term problem, though, is that then those developers become the intermediaries and the publishers, and the question is, that the employees of those people, especially in a state like Massachusetts with non-compete laws, actually fueling their own smaller version of the same bigger monster.
The other thing is, within these big organizations, there'll be people who are, truer to the creative aspect, and there will be bean counters. And that you're not talking about a monolith when you're talking about especially these larger corporations. So a lot of, in publishing, there'll be editors who are very supportive and nurturing, and who see their job as protecting their authors and creating a safe space for them to do their creative work. And there will be bottom line kind of people. And I think one of the problems with digital is this convergence in this, with fewer and fewer publishers of music and books and movies, the margins get squeezed, and there's less and less space for those sort of old school values for those people who, the traditional sort of editor, nurturer, talent agent who sees themselves as an agent of the artist.
Well, and just to clarify, because maybe I didn't mean to misspeak, but I guess the idea of investment being both financial capital investment, like I need your money to make this thing or I need your money to buy these ads, but also the other side of investment being the benefactor style, which is sort of, copyright sprung out of this idea. Like, there were people with money who wanted to make the arts happen, and then who owns the rights to those things once I've paid you to make your opera? And I guess there are as many great people at Activision and Electronic Arts who want to make really cool, really artistic video games that also make money, and then there's people who are just, the bean counter operations people who just want to churn product into the channel and get the money back.
But Terry, I would like to just add that I mentioned earlier that I sometimes feel like I'm between the sort of copyright industries and the copyleft.
With these arrows coming.
With arrows coming both ways. And I would say that most photographers, professional photographers, would say that they have less leverage with the copyright industries because they're hiring us and they are using terminology in their contracts to gain more rights for less money. Then sometimes we have on the copyleft where at least it's free. So I sometimes, that's why I said it, sometimes depending on the day, I'm not sure which side the arrows are more hurtful from, but it's changing. Like I said, the digital revolution has kind of changed all of the power, and not necessarily in a good way.
Something Terry asked reminded me, you were talking about what motivates artists. I know in the world of comic books, there are many, many examples of people who have left secure work-for-hire gigs at Marvel and DC because they wanted to have a creator-owned property that they would create themselves. And some of them have been very successful, and some of them have not been very successful, but people have definitely made choices because they wanted to own their own IP. And what ended up happening is that now within the big two, DC and Marvel, you will have things that are owned by DC and Marvel, and you will also have certain characters and properties that are creator-owned characters, if the artist has a market power that they are able to get that deal struck. So I do think the ability to own your work and make decisions about it has definitely motivated the conduct of at least many artists that I can think of.
I'm neglecting this, Andrew.
So I think that each of you has expressed intuitions about the emotional connection between creators or groups of creators and their work. And I'm curious, I suppose, about the degree to which you think these should be protected, or whether or not, I guess, they should be protected, the degree to which they should be protected, and how you'd like to see this go forward.
I'm not sure I really understood the question. What was it?
I'm sorry, I should say that each of you has expressed like sort of emotional intuitions, like this is stealing when someone does this act. Mm-hmm. How do we, as lawyers, look at that? How would you like to see us as lawyers look at that and develop rules about that? What do you think, how should we think about stealing? What should be taking, what shouldn't be taking?
I think that something you expressed earlier was just the idea of, I think if you're a lawyer advising a client who is a creator, I think the idea is that you want your creator to have agency in how they're applying copyright to their works, right? Not just to assume there's a system that protects them, and I don't know, and someone's using something that's mine, and I want, like the misconception I was referring to earlier, like the idea that like we worked on this, and so it's all protected, but to really have them say, no, I want my works protected in this way. You know, I want to make sure that this part of it, you know, I'm going to file a patent if I'm a video game company because this kind of technology is actually a patentable thing and I don't want someone else to ever use it in the same way versus a trademark versus copyright. And there's sort of these tiers that you really need to have a client who's educated and want to be part of that educational process, because most creators, like when I was just in a band, like I learned about Creative Commons because I thought it was really cool and I love the idea of sharing music with people, but also like I didn't know what the hell I was talking about most of the time. Like it's I'm a drummer in a band. I hit things with sticks for a living. I don't know about copyright law, and if I talk to a lawyer friend or talk to a lawyer who is advising me professionally, I'd really want them to have a nurturing relationship with that and not just explain the system, but explain the system and how it applies to me and how the emotional connection you're talking about, though, is I think you assume that something you created is yours wholly, and I think that as creators are getting younger, I think people, and you talk about sharing services like Instagram, they feel less possession over it because they know when they're using a service to share their stuff for free, like you're using Facebook or Instagram, like if you're using it for free, you are the service, right? Like you are the one, like your media being on that service is like why you're not paying to use Facebook. If you're paying to use Flickr Pro, like you can protect the crap out of your photos, right? Like people are really not able to grab your stuff, but I guess the creator agency is what I would really direct you to say. You need to tell your clients, like, if you want to protect it aggressively.
But God forbid, Instagram, you might be putting it for free, but God forbid that they say, no, we own it, and now we want to.
Well, they do own it. It's in the terms of use you clicked on.
Which is problematic.
Which is problematic, but also, like, if you don't want to use it, don't use it.
The other thing I would say
is, don't click on
it. Just to respond to that, I personally, I feel less, and I don't pretend that this is a representative of all authors or all creators. Sure. To me, all works are derivative. And, when the book is done, this is all along a spectrum. And there's fan fiction or direct covers at one end of the spectrum. But, once you're into that gray area, everything is imitative, everything follows, everything borrows ideas. And in the end, that's what we're all selling is ideas. A book is a collection of ideas. A photo is a collection of visual ideas. These are all just ideas. I was talking with a scriptwriter at the studio that was interested in buying one of my books for TV. And without getting into the specifics, they said, well, in the end, if you don't sell us the whole idea, we can just, there's a book set in Boston in the early 60s. And they said, well, we'll use the setting and we'll just change the characters enough. Nobody owns that idea of Boston in the early 60s. And when they said that, my reaction was not what my lawyer or agents would have been, which is, that's outrageous, we're suing. I thought, well, yeah, that's true.
You didn't invent Boston in the 60s.
I didn't invent Boston in the 60s, and I don't own these stories. Right. I know a film agent who can, you tell him a story, and this is his gift. He's like Rain Man. His gift is you can tell him any story and he'll tell you it's X meets Y. And it's always perfect. And so, you know, that is true. In fact, I've taken some of his formulations to describe my own books now because they're perfect and it always works. And so I think that this emotional connection, you know, I just don't feel it. You know, you create the work, you put it out in the world, and then there's either an audience for it or it isn't. They'll either appreciate it or they won't. But you create it and then you move on to the next. And, you know, you trust these business managers who surround you to make sure it doesn't go too far. And, you know, obviously I'm in a privileged position that there are people who would protect that. But, you know, personally, on the creative as opposed to the business side of me, I don't feel that emotional link at all. When I'm done with a book, I'm done.
But, you know, going just to your question, you know, I usually say on the first day of my class, unlike criminal law, where you can understand you shouldn't kill people, society should have that rule, there's not obvious natural law of IP. You know, society makes choices. Should the term be 10 years, 100 years, 50 years? I mean, those are choices. That no stone was inscribed with what some of those rules should be. But the Constitution, which I do think has worked pretty well, does say that there should be copyright and there should be this limited monopoly to give people the chance to have it be an incentive to encourage them to create. And I believe if you look at our economy, it's worked pretty well to incentivize and encourage creation. And so we need to protect that while also balancing against the rights of others.
A very nice note to end on. So we're out of time, in fact, a little over time. Thank you so much for lending us the benefit of your experience and wisdom.
Thank you.